Good morning, everyone. If you could all please take your seats, we're going to get started. Just as a reminder, in the back of every section of your program, there's a survey for each of the CLEs. If you could please fill out your survey for the CLE at the end and turn it in at the back. And then if you were at the early bird, if you could also fill out the survey for the early bird, they would really appreciate that. So this morning we're talking about eDiscovery, law, practice, strategy, and sanctions. We have a great panel of speakers today. Our first speakers are Bob Trzinka and Colleen Z. Bob is an attorney with Cutler, Idaho, and Sioux Falls. He graduated from Harvard University with a degree in sociology in '98, and then developed software for the financial industry. He received a law degree from the University of South Dakota in 2011, and has been working here in Sioux Falls since 2012. Colleen Z is a consultant for computer forensic resources in Sioux Falls. And what she does, she's an attorney that has been practiced in Vermillion for a year, and met Dan Mackey, who is a computer forensics expert. And she tries to bridge the gap between attorneys and the expert in the eDiscovery world. So they're going to get us started with translating technical to practical with the eDiscovery tips from an expert and an attorney.
Thanks, Jess. Hopefully everyone can hear me. As you said, my name is Colleen Z. Thank you so much to the bar and the CLE committee for having me here. It's a complete honor to speak to all of you, and thank all of you for being here today. Quick reminder, there's a panel discussion at the very end after everyone's spoken. So if you have any hypotheticals or questions throughout our presentation or either of the judges' presentation, hold that thought and make sure to present it at the end so you can get the viewpoint from every single one of us. However, during our presentation, if you need clarification, if we said something that doesn't make sense, or you want us to define something a little bit further, please feel free to raise your hand so we can address that at that time.
So, eDiscovery. We've all heard that it's important, mostly because everybody's told us that it's important. And so the question that many people have is, what is eDiscovery? Well, we're going to let you in on a little secret, folks. It's a big one. We don't like to talk about it very much. But eDiscovery is discovery. And discovery is taken in many forms. And discovery changes, technology changes. And that's literally all eDiscovery is that there are new tools and techniques and rules that are associated with eDiscovery that have evolved as the technology has evolved. And so we're going to hopefully help talk about that for you today. And so the difference between eDiscovery and regular discovery is there's a good chart here, and this talks about the difference between the two, is that for the most part, you're relying on the same case law. A lot of the case law that you're relying on for regular discovery, those rules still apply. You're still relying on the same rules of civil procedure, the rules of evidence that you do for regular discovery. You also have the same ethical considerations under eDiscovery as you do with regular discovery. You also have some additional considerations, and that is the role of technology in eDiscovery. And ESI stands for electronically stored information, and that's a lot of the times the information that you're trying to discover in eDiscovery. And then you also have what's called the Sedona Principles. And the Sedona Principles are a set of recommendations, rules that were set out by the Sedona Conference to help lawyers do a better job in discovery. And the Sedona Principles became particularly important when Judge Scheinman, out of the Southern District of New York, wrote the 4 Zulake opinions, which form really the backbone of modern electronic discovery. And so, if anything else, read the Sedona Principles, read the 4 Zulake opinions, and you'll be fine.
When over the years since I've been studying electronic discovery and working with lawyers, one common theme is, what's eDiscovery? And my response is generally, if you're practicing law, you're working with humans, you're already dealing with eDiscovery. Similar to what Secretary would write on a carbon copy pad 30 years ago is the voicemail today. And something to consider is, if the information can be retrieved, then it's discoverable, and a requesting party has the right to seek its production. So just because it's electronic doesn't make it anything different. It's just it just adds a little bit more questions as to how to handle it, and a little bit more forward thinking. And additionally, eDiscovery isn't just in the civil field. It's pouring into the criminal side, and then of course regulatory matters.
So as you saw before, the rules, there are many different laws and statutes and rules that are in play. You've got the federal rules, from whether it's party discovery or it's third-party discovery with subpoena, that all applies. You also have the federal rules of evidence, and there is a lot of interplay with the federal rules of evidence and e-discovery. I'll talk about that a little bit later. But then also we have the South Dakota statutes. Now, there aren't any South Dakota statutes that pertain specifically to discovery at this point, and to a certain extent, that's a good thing, because the status of e-discovery in South Dakota is
unknown. But before I go to that slide, I do want to make a point. One of the biggest things that people refer back to is the 2006 changes of the federal rules. And really what that helped do was clarify that electronic records have a place in discovery. Before then, it was a little vague, and that was what 2006 changes really pushed through. There are some proposed amendments that may or may not go through in 2015. There's a lot of resistance. I would recommend looking, we included in the materials an excellent article by Thomas Allman where he talks about a lot of the thought process in going into the potential amendments to the federal rule. And whether or not that they get passed or approved, I still think it's a good starting point to help you make your arguments when it comes to eDiscovery. Because whether or not the rules get changed, eDiscovery is here to stay. So knowing how to handle that evidence is a good way to move forward with your argument. So consider that and read that material to help learn a little bit more about eDiscovery.
What I would just say about the proposed amendments to the federal rules is, I would be surprised if they passed in current form, just simply because there's a lot of concerns that the rules as they're currently formulated, the proposed rule changes, I think, will just cause, rather than decrease problems and decrease fights in discovery, they will actually increase the fights in discovery. And so I think that's one of the primary reasons why they'll probably not pass. Now, the status of law in South Dakota and the status of statutes in South Dakota regarding eDiscovery is relatively unknown. And to a certain extent, that's a benefit to us as attorneys, because we can use other states' experiences and we can see the mistakes that other states and other jurisdictions have made over the years. And hopefully that helps us make better choices about eDiscovery. And the other thing that I think is useful, and part of the nice thing about the way eDiscovery is in South Dakota right now, is that the South Dakota Supreme Court has consistently recognized that where South Dakota statute mirrors a federal statute or a federal rule, we can rely on the federal case law. And there's a lot of very well-established and very good case law in the federal courts regarding eDiscovery. And so we can really use that as a guidance for what we do. And so the big thing that we as attorneys here in South Dakota can do, the best thing that we can do, is to educate ourselves about the eDiscovery rules in the federal courts all over the country, so that we can hopefully apply the lessons that other states have learned here.
And I'm very excited to hear Judge Whiteley talk. He's a state court judge out of Rapid City, and I think he's going to address the status in South Dakota. And I, for one, have been very excited to hear him speak. From my viewpoint, I think that we don't have much case law on point because we just don't have the quote-unquote big data cases that eDiscovery usually gravitates towards. And I think as lawyers, you recognize that you're not dealing with 9 terabytes worth of data very often, and you're not having to think about technology-assisted review. Instead, you've got one computer and a cell phone, or you've got a company that you're wanting email from. That's still eDiscovery. And there's certain parts of eDiscovery that you can pull into your practice and educate yourself and still participate in that part. But I think that might be why South Dakota is a little bit behind in that sense. But without a doubt, reasonableness and common sense should get your way. Ethical considerations. Obviously this is a big part of everything that you do. And there's a lot of things up here. And really what eDiscovery does is it should rise your sense of awareness of your ethical duties and considerations. And the biggest thing that I'm going to talk about is competence. Technology is something that you just have to embrace. It's here to stay. And so you need to start educating yourself about what technology is out there. What technology is your clients using? Where is it going? Where is it located? And you're sitting in this room today, you're sitting in a CLE, so you're starting to educate yourself. When we put together the outline, the majority of it is sources for you to go and start to read and try and just really start to embrace the concept of eDiscovery. I encourage you to follow the thought makers. I don't necessarily like that phrase, but Craig Ball is a wonderful wealth of information, and there are some really great people out there that can steer you in the right direction. So really embrace it and start learning, and it gets to be pretty exciting, and it's going to be a game changer in your practice.
The area of the ethical considerations that I sort of wanted to talk about just briefly here today was the role of candor in eDiscovery. Having candor with your opponents, with the opposing counsel, it's always a good thing. The biggest issue with eDiscovery is that it's the easiest way for someone to play hide the ball. So easy. Whether you're the plaintiff or the defendant, it doesn't matter. If you're responding to a discovery request, eDiscovery makes it very easy for you to hide the ball. And so, but by the same measure, we as attorneys owe each other, and we actually owe the court, because the duty of candor is not necessarily to each other. The duty of candor in discovery is actually to the court rather than to each other. Is that, if you have technology, you have issues with the technology, you have to tell the other side why you're having troubles with the technology. Like, here's a perfect example. When you want to say that something is burdensome in order to produce it, let's say your client has computer systems that are very difficult to retrieve data from. And you want to say, no, I'm not going to turn this over because it's going to be very burdensome to do so. If the other side has asked you, well, what is the technology that you have, that your client has? And you say, well, I'm not going to tell you that. It's sort of hard for you to substantiate your allegations of burden unless you tell the other side, well, here's why. And that includes a description of the technology in play, the technological issues that you have, the data custodians that you have, the ability of your data custodians to get to the data that the other party is asking. You know, if you don't have candor to the other side about it, then you've got a real problem. There's another ethical consideration, and that's what a lot of folks talk about data mining. Now, there are several ways that people refer to data mining. The most common way that we as attorneys hear, and I take a little umbrage to this, and Colleen and I had a long discussion about this the other day, because as a former technology person, when I hear data mining and folks talk about simply metadata as a data mining, I'm like, that's not really data mining, that's not data mining. But it is considered data mining. So when you create a document, typically in one of the office products, there's data that floats in the background. And you have to be cognizant of that data. And you have to be cognizant of spoliation issues with regards to that data. I'm going to let Judge Schreier talk about that. You have to be concerned about disclosing former client data. In fact, I can't remember the state, but there's an excellent ethical opinion where an attorney got in trouble because he did something, and I'll really admit, I'm guilty of that also, where the attorney took a form, a pleading, that they had used for a prior client. And rather than just copy and paste, they did a save as. Well, when you do a save as, that metadata is still lurking in the background. And that can contain client data. And so if you just do a save as and you don't scrub that data, you can be inadvertently disclosing client data to third parties. And an attorney was disciplined for doing that. The other issue with regards to data mining is from a spoliation perspective. Is that, there may be important issues, there may be important things in that data that sort the metadata. And if you scrub the metadata, you can get rid of all of that. Now, you may think that's not really important, but where date's modified, where modifications are important, where edits to the document, where knowing what those edits are, but that's important. Scrubbing that data is spoliation. Spoliation. Sorry, I will hold the microphone close to my face. That is spoliation, and that's an ethical consideration that we have to discuss. So it's actually, there's a lot of complications with ethical considerations with eDiscovery. So.
All right, pre-litigation. Basically what this means is anything that happens before the triggering event. And why is this important to you? Well, until you can't necessarily effectively work with technology when that triggering event happens if you have no idea how companies organize their data. So learning how, and self-admittedly, this is the worst slide I've ever created, and I apologize for that. But I put this together with the knowledge that you have it in your books, and you'd be able to refer to it. And basically what all these words say is every company handles their data differently. There's no one right way to do it. But generally, they should be doing it reasonably, in a defensible manner, so delete purposefully, not just deleting all willy-nilly, and have good management practices. And at the end of the day, some courts hold the more sophisticated parties to a higher standard. Something that's in the news today is the IRS. How do you lose 2 years worth of emails? They're held to that higher standard because the IRS should have some backup tapes, should have some archive, some email back there. So understanding that companies handle their data differently and not assuming that you've worked on a case with one company before and they handle, their emails a certain way. Don't assume that it's the same way as that. Let's see. And if you are have in-house counsel, or if you have the opportunity that you work with a company on a continuing basis, work with them on thinking about how they manage their data. Because at the end of the day, the cost of eDiscovery is going to be directly determined on how they handle their data internally. And if they're keeping everything, think about what you have to preserve, and then you have to filter through all of it. So if you can have a part in how they manage their data, and have them come up with, certain strategies of defensible deletion and policies, and then that will help them that when something happens in the case where they may get sued, they'll be able to manage their data more effectively and assist with the eDiscovery process and keep those costs down.
Now, for your corporate clients, when you have corporate clients, knowing the data, it's not a question of if, it's a question of when. Because eventually, your corporate clients, they're going to be involved in some sort of litigation. And increasingly, that is going to involve eDiscovery. And the important thing about it is for your corporate clients to make sure that they document things. And I know that with our corporate clients, one of the things we've said to them repeatedly is, listen guys, you need to document what you're doing better, because it will help you both. And one of the ways that you can sell to your corporate clients is that doing the right thing for eDiscovery is nothing more than doing the right thing for their data anyway. Because there are numerous consulting firms that their whole reason for being is to help corporations, companies, mom and pop shops organize their data better. And why is that important? Because it helps two things. One, it helps you when you are trying to represent your client. But then two, good data management techniques helps the bottom line. It makes your corporate clients profits. I know when I was at Fair Isaac, Fair Isaac is a pretty big company, and one of the things that I did for Fair Isaac was I helped create a knowledge base for the company, and that was important to Fair Isaac, and it's increasingly important to corporations, because it helps the companies. If the company knows what everybody's doing and the company can easily access that information, that makes it easier for the corporation to do their business in a better way. When everybody knows the data, it's a whole lot easier to do your thing. If it's siloed, meaning that it's in discrete parts and one hand doesn't know what the other is doing, that can cause trouble, not just from a litigation perspective, but from a corporate profits perspective. Because folks doing things on their own, they don't necessarily know what the other hand is doing, and you can end up with conflicting messages or conflicting rules within the same corporation. And eDiscovery operates a lot of the time the same way that we all look at cases. We have early case assessment, and that's the same whether it's electronic discovery or it's regular discovery. You still do the same early case assessments either way. However, with eDiscovery, you have additional complications, and that involves the data assessment. And so one of the best thing that you can do to help